Judgment in the appeal, Wood and Capita Insurance Services Limited.
I'll ask Lord Hodge to explain the decision of the court.
This appeal concerns the interpretation of an indemnity clause in a contract for the sale and purchase of the shares of an insurance company. The principal question is whether the indemnity, which the sellers granted to the buyer of the company's shares, was available against losses caused by the mis-selling of insurance products generally, or only for such losses pertaining to such mis-selling as arose out of claims against the company or complaints made against it to the Financial Services Authority or other public body. The clause in question is far from a model of clarity. At first instance, the High Court interpreted the clause in the first way, that is, as allowing the buyers to claim the indemnity from the sellers for any losses pertaining to the mis-selling. The Court of Appeal disagreed and held that the indemnity could be invoked only when the losses arose out of claims against the company or complaints to the public authorities. The buyer, Capita Insurance Services Limited, appeals to this court. In its appeal, Capita also sought to raise a more general question about the appropriate way to interpret contracts. It claimed that the Court of Appeal had erred because it had been influenced by a submission by counsel that this court, in a decision in 2015 called Arnold and Britton, had, and I quote, rode back on the guidance which this court had given in 2011 in a case called Rainy Sky and Cookman Bank. This, it was asserted, had caused the Court of Appeal to take an unduly literal approach to the interpretation of the disputed clause at the expense of a more contextual interpretation, which gave scope for the court to apply business common sense to the task of contractual interpretation. In a unanimous decision, this court dismisses the appeal and expresses its view on the wider question of the correct approach to contractual interpretation. On the wider question, the court holds that it must ascertain the objective meaning of the language of the contract. It must consider the contract as a whole and, depending on the nature, formality, and quality of its drafting, give more or less weight to the elements of the wider context in reaching its view as to that objective meaning. The quality of the drafting is an important consideration for the court in striking a balance between indications given by the language used on the one hand and the practical implications of competing constructions on the other. The court must also be alive to the possibility that one side may have agreed something which, with hindsight, did not serve his interest. Textualism and contextualism are not competing paradigms in a battle for exclusive occupation of the field of contractual interpretation. Rather, they are tools available to the court to interpret contracts, and one tool may be more helpful than another in relation to a particular contractual provision, depending on, among other things, the quality of its drafting. On the approach to contractual interpretation, Rainy Sky and Arnold were saying the same thing. Applying this approach to the share purchase contract, this court holds that the Court of Appeal was correct in its interpretation. A careful examination of the wording of the clause shows that on Capita's approach, much of the wording of that clause is surplusage and imposes no limits on the scope of the indemnity. Capita's interpretation also fails to identify against whom the claims must be made to trigger the indemnity. Mr. Wood's interpretation doesn't suffer from those problems. The contractual context is also important. The disputed clause exists alongside very detailed warranty provisions in a schedule to the contract. The warranties give the buyer wide-ranging rights against the sellers, which could cover, among other things, the mis-selling of insurance products. But those warranties had to be invoked within 2 years of the completion of the sale. That was not an unreasonable timescale to allow the buyers of the company to investigate the company's business operations, including its sales practices, and make a warranty claim. It was not contrary to business common sense for the parties to agree wide-ranging warranties which were subject to a time limit, and also to agree a further indemnity which was not subject to the time limit, but which was triggered only in limited circumstances. Capita may, with hindsight, have made a bad bargain because it did not invoke the warranties within the time limit, but it is not the function of the court to improve its bargain.
Thank you very much. Well, we're now adjourned.